Well, good evening, everybody. This is Jonathan Ginsberg. Welcome back to our live stream. Tonight I have a guest, Lindsay Osterhout. Lindsay and I go way back. We've presented CLEs together. We've discussed cases together. She's a big part of a law firm called Osterhout Berger Daily, I guess is now what it's called. And they've always been very, very generous with me, sharing their expertise, their knowledge. I have a question about something I don't know. I'll pick up the phone and call, and I usually get a good answer, or they make something up. I don't know. Either way. But
my dog, you can hear my dog. I'm so sorry.
That's okay. That's okay. I at one point I would have my dog in here, but she would like to decide she wanted to play right in the middle, so I banished her. But dogs are okay. So, any case, what I'd like to do, I know we've got a bunch of questions already in the comments here, but before I get to that, Lindsay presented at the latest NOSCR conference about a month ago. NOSCR, for those who don't know, is the National Organization of Social Security Claimants Representatives. Actually, I did my first live stream from NOSCR in Nashville last year around this time. And then I did not go this year. We had some family issues. I think I've mentioned I had some father-in-law fell, had some issues there, so I couldn't go. Lindsay did go. She did present. And you know, right now, Social Security, as you probably all know, is sort of in a weird place. There's a brand new commissioner who just got confirmed, I think, last week. Frank, how do you pronounce his last name? Bisignano, maybe? Yeah, he was a head of a finance company. And it's interesting because Adriana De La Torre, she did a post. She's another disability attorney. And she said, you know, she thinks it's a positive he comes from outside Social Security, which is an interesting perspective. You know, I think the goal is to try to run this more like a business. And I will tell you, and I don't know if you've heard this, but I've had people from within that used to work there, even still work there, think that there is a lot of fat, you know, at the top. Whether the cutting is too great really remains to be seen. But anyway, what anything in particular you picked up at NOSCR this year of interest?
A couple little things. I would say on the new commissioner with kind of the business background coming in, I've always thought Social Security, I don't know if you've seen the movie Office Space, where the two Bobs come in and they kind of cut any slack. I've always joked that the agency could do that. So I'm going to be hopeful rather than pessimistic. But thank you for the intro. I have to say, I love working with you. And anytime I've picked up the phone or sent an email, you've been just as helpful back and amazing.
That's one nice thing about this area. I think most of the people who do this type of work, it's pretty cooperative. There's a lot of business out there, and it's not like, you know, people are fighting over cases. And so, you know, we all sort of have the same goals to help the people that need our help. And so, you know, if you have a question, you post it on the listserv or you pick up the phone, and usually people are pretty helpful. And it's really nice to have, because especially your firm, they do a lot of the appellate work. I know your husband, Carl, has been really, really, you know, great to work with. A lot of times, if I have an unfavorable decision, I have him review it. You know, he'll help me, or he'll decide to, you know, co-counsel with me on the appeal. And it's really nice to have that background, because I'm a solo basically. I've got, you know, staff, but I mean, it's nice to have the backup of a firm that does a lot of different elements of this, because it can get kind of complicated. It really can.
And even just having someone to bounce ideas off with is really key, because it is hard when you're isolated, for sure. And sometimes within my own office, I'm like, I need to go talk to someone.
I know. It really can be, just because there's things that, you know, I've been doing this for 30 something years. And I started I was like 10. That's why I look so young. But you know, and you know, there's always something new. Like the other day, I had something come up about income and resource issues in an SSI case. I don't do a lot of SSI, but this popped up, and so like 4 or 5 people, you know, responded and kind of led me in the right path. So anyway, back to NOSCR. You said that. Will you just continue on? But what you picked up and anything interesting you heard?
Well, I had the opportunity to present with a prior ALJ who actually was a regional head ALJ and also a decision writer. So I learned a lot of neat stuff from them about what goes on behind the scenes, which was kind of the point of our presentation. kind of, okay, we had the hearing, now what happened?
Right.
I found out some cool things like decision makers are allotted X amount of time per decision. And if it's a favorable decision, they can have 4 hours to write it. If it's an unfavorable decision, they have 11 hours to write it. So that was an interesting tip that I learned. And I guess it's really stringent, at least when these folks were still back at the agency. Of course, things have changed possibly since like the 3 or 4 years that they've been gone. But I would guess that they still have the same pretty high productivity standards, which you wouldn't expect because sometimes we're sitting so long for decisions.
Yes. Yeah. That's right.
Fun. But it certainly isn't because they're not supposed to be getting them out.
Right. Right. And you just wonder, I mean, because I know that, just talking a little bit about appeals and that's a topic for a different day, but, when you appeal an unfavorable decision, you're typically looking for some sort of an error of analysis and realize the decision writers are not at the hearing and they're listening to a tape, but they're not hearing it in real time. And I think you also told me, we talked a little bit before this, that there's not really a lot of communication or any communication between the decision writer and the ALJ, right?
Yeah, which I found really surprising. I thought it would be like collaborating. You kind of peek your head around and look in the ALJ's office. I got a question on this case, but actually there is no cooperation at all, no communicating other than the decision writer basically gets the file and it, with yes, no, and some notes from the ALJ and they got to go with it. So definitely different than what I thought.
Yeah.
So
Interesting.
it was interesting.
Yeah.
It was really nice. We had a nice turnout of folks that came to join our session.
I'm sure. So what did you, with the judge, I know you've got Sherry Ann, a former judge in your office now. What have you picked up about the way judges look at cases, if anything? What's the, because I think a lot of people, they're joining us tonight are going to want to know what what judges are really looking for. Any sense of that? I mean, obviously based on your experience as well.
Yeah, I think working with Sherry Ann helps me even be a better attorney and a better rep for my clients. She's given me some great tips. Like she has really focused on the idea of, excuse me, pointing out in the medical evidence and making sure that's really clear to the judge ahead of time where different limitations, where different like medically determinable impairments, I was going to say MDIs, but making sure that the judges know clearly where these things are and just really write them a roadmap before you go into the hearing. Because her thought, at least on some things, she kind of felt like walking in, she had a sense of what she was going to do. So I don't know that all judges are like that, but certainly if you can catch them before the hearing and already start to kind of work your message in so that hopefully that sticks, I think that's probably like a really good tactic to use. So.
Yeah, that makes sense. I know that a colleague of mine, Chad Brown, he had an interesting video that he talked about that he felt like that, and he kind of looked at the percentage of judges that have a high percentage approval, kind of going with the idea of how do I approve this case? The ones that are the 25%, pay are like, how do I, I'm going to disapprove this case unless you show otherwise. And my thought is there's probably in a judge's mind kind of a model of what they expect, let's say for a back pain case, what they want to see, what they expect to see. If they don't see it, they're not going to approve it. And so, again, this gets back to the whole notion of why objective evidence is so important, because it's just a lot easier to work with a MRI with a herniated disc than it would be for an idiopathic pain condition or a fatigue case, just, because you can't really, credibility is no longer an issue. It's really about what the evidence says. But what you're saying obviously makes a lot of sense, is that, give the judge a roadmap. This is the exhibit where you can see this, and this is why you ought to follow it my way. So definitely makes sense.
I even thought to kind of modify my briefs a little bit, and instead of so much of kind of telling the story in a sense, I almost went to bullets. Like, hey, Judge, here's where this test is, and just did the exhibit in bullets, and we'll see how it goes. But that's my tactic.
Yep. Yeah, I'm sort of playing around with my format as well. At one point I really had not followed the 5-step process, and then I'm starting to put that in there, as again, because that's what decisions do. I just looked at decisions, and so let's just make it easier for them. All right. Well, I got a bunch of questions. Let's kind of go. Let's see here. This one is not really a question. This is someone who filled out a form. So Stephanie, I'll follow up with you on that. I just want to let you know that I did get that. All right. So Shub says, can LTD garnish SSDI? Asking for a friend, and he's talking about a clawback clause. And I think what he's getting at is, if you have a long-term disability claim and you're getting paid, if it's a company-provided claim, most of those provide that if you collect Social Security disability, if you win, you've got to pay back the long-term disability company for any months you've got long-term disability and Social Security. Their argument is that Social Security, the long-term disability premium, is reduced because of the expectation there'll be an offset for Social Security disability. The answer is there's no garnishment of Social Security, legal garnishment, but you did sign a contract. So theoretically, you could be sued on that, and certainly many times the long-term disability benefit is going to be higher than Social Security. So let's say you're getting from long-term disability $3,500, Social Security is $1,500. Maybe there's another, whatever the $2,000 is going to be made up by long-term disability. If you don't pay them back, you're not going to see that. They're going to offset that. So I think in that sense, you've got to honor the contract there. All right. So here's one, and I see this one a lot. Laura says, I called DDS to see if they need anything else from me. It's been 9 months. They said no, they have everything from all parties. They're waiting for my analyst to make a decision, then they'll review. They told me the analyst number, blah, blah, blah. So, I mean, you're seeing this, I'm sure, as well, is that these initial decisions are taking a long time. So tell me if I'm wrong. My understanding is the adjudicator, the person, the claims manager, is gathering information. Then they send it to a medical analyst for review. Is that what happens? And then, then what happens then? Does the analyst make a decision? They just make a recommendation? What happens at that point?
I believe they make if you kind of notice, if you can look in a file, you will actually see their decision in a sense, DDS's decision. And a lot of times you see that analyst analysis of the case in there, whether it's the physical portion or they send it to a mental health provider for the analysis, and then they will use that to work towards finding the residual functional capacity that they decide either to deny or award with.
The medical analysts, who are these people? These are obviously, most of them are medical doctors. Where do they come? Any idea where they come from? Are they just people that make a little extra money? They get on the panel. Is that kind of what happens?
Yeah, it seems like there's folks that are medical analysts in that sense. I don't believe that they're staff. I don't believe they're Social Security staff, but even for consultative exams and things, there's agencies that have medical providers on staff that then are contracted out and provide these types of services. So I'm not sure how to get that job.
Yeah. Well, I know, I've seen a number of certainly in the consultative, there's now companies that provide these services, and I guess they provide them to long-term disability, other insurance companies. Needless to say, my experience has been the physical consultatives are rarely very helpful. The psychs consultatives tend to be a little more so. Is that your experience as well?
Yeah. I've definitely seen the same. I mean, occasionally you can get a helpful physical CE back. And sometimes it's frustrating when you have that in the file and then you have an ALJ that then orders another CE.
Yep.
And, because you have maybe a case where the person's going to grid using these vocational rules in the regulations, and you have the CEE to waive, and then they go and get a post-hearing CE trying
get another one.
Well,
because I've seen it where even the adjudicator will send off for, the one comes back and is very favorable to the claimant. Then the next thing, 6 months later, they send them out for another one, almost like they're looking for a reason to deny. So yeah, that can be a big challenge. And the other thing I see with a lot of these CEs is, they don't say anything. I mean, it's basically the doctor, or sometimes it could be a PA or a, nurse practitioner will just kind of report what the claimant said, but they won't make any functional analysis. They don't really say anything of value at all. It's just like, they came to see me and this is what they're telling me, and that's it. So it doesn't really do much at all. My understanding, and again, you correct me if I'm wrong, is that the reason that we even have CEs is because Social Security has an obligation to develop the record. I mean, there's really no other reason for it. I mean, I would think, you got, somebody's gone to the same doctor for 10 years, that would seem to be a lot more valuable. And of course, we used to have the treating physician rule, but I kind of wonder why. And I'm actually seeing fewer CEs even. I don't know if you are, but I'm seeing fewer, almost like they don't want to spend the money.
Yeah, absolutely. During COVID too,
Mm-hmm.
seeing no CEs. And one thing I think is interesting too, I've spoken with like some adjudicators at the local offices or at the DDS level. And when they order records, they follow up like once or twice, and then they're like, oh, we couldn't get them.
Yep.
So certainly if you have a supportive doctor, or and they'll write you a letter that you can send in, or you can even try to get some records yourself. Sometimes that is helpful, just because they're not going to
do
make
much
the extra effort.
No, that's actually a really good point. I think a lot of folks, they get frustrated it takes so long, and what's going on behind the scenes is the adjudicator sends out a letter to the doctor, and I think they pay $15 or $20 for the records, and realize perspective-wise that many of the medical providers are used to dealing with personal injury lawyers, things like that. And some states allow $500, $600, $800 fees for these records. So so the copy service gets a letter from Social Security that says, we're going to pay you a whopping $20, and they just ignore it. And then the adjudicator sends another request, they ignore that. And then you get the decision from the state agency, and it says, well, we're making the decision based on these records. We couldn't get records from your rheumatologist, from your orthopedist, from the hospital. And so the decision is being made with incomplete information. And like Lindsay says, if you can get those records to Social Security, that can be helpful. And certainly as attorneys, we have access to the electronic system. We can get them uploaded electronically, which is actually kind of a big deal, because if you're trying to do it yourself, you got to fax it to some number and who knows where and hope that it gets associated. And if you don't have a barcode, it's probably not going to happen. So, it can be really a challenge to get those records in.
Yeah, definitely. And it is nice too, now that we can see the new application and the reconsideration of what they actually have, because before that, we couldn't even know what they got or didn't get until after they sent the denial listing.
Yep. And what you're saying is that, what Lindsay's saying is that up until maybe a year and a half, 2 years ago, we wouldn't be able to see the file until we got to the hearing stage, which means the initial and recon, the first 2 years was like a black box. We didn't know what was going on. Now we can see. So you can not only can see what they've got, you can also see if there's activity on the file, which is helpful, because if there's not, you can at least write a letter or do something to try to get things moving a little bit, which is helpful. All right, RIP DT, I don't know, I'm not going to try to figure it out, but let's call him RIP. Ask the question, can an ALJ tell you your symptoms are going to heal? Then tell me what my doctor said is speculation. I guess what he's getting at is, can an ALJ make, assumptions about the progress of a medical condition or whether something's likely to get better? Do you ever see that? Is that something that they're supposed to be doing?
I have, or a common one I've seen ALJs tell folks, well, if you lose some weight, your back pain will probably feel better.
Mm-hmm.
I absolutely think it's wrong of an ALJ. Now, is there a rule that they can't say that? No, they can say those kinds of things. But that's why it's important, because then if they're going to deny you using that, they have to logically back that up in writing. Well, or the decision maker or the decision writer, I guess, does. So whether it actually stands in a decision is different from maybe just offhand remarks that an ALJ makes.
Yeah. And sometimes, by the way, there can be a disconnect. The ALJ will say something like that at the hearing, It doesn't get into the decision because I guess the decision writer realizes that it's not supposed to be something that should have been said, but it was said anyway. Which is why I tell people, if you get an unfavorable decision, you should get the audio and listen to it. You'd be surprised, there may be grounds, and I've never made this argument, but there could be grounds that, there was something that the judge said in the audio transcript that could be prejudicial that you could use as grounds for appeal, something like that. I remember there was a judge in Georgia, I'll just leave it at that, who, if a person was a smoker, no chance. He would ask the person on the record, how much do you spend in cigarettes? I smoke, a pack a day. And so, he'd say, well, I know a pack of cigarettes costs, $4. I don't know what it's back. Let's assume $4. He goes, so you're spending, $30 a month, whatever it is or a week on cigarettes. And that's, $130 to $135, $40 a month on cigarettes. But you say you can't go to the doctor because you can't afford it. Well, if you stop smoking, you can go to the doctor, setting aside what I understand to be how difficult it can be to stop smoking. But again, that's the way some judges look at it. So, you just have to really listen to it. Again, I think, get a copy. I tell my clients, I'm like, look, I'll get you a copy of that audio. You should have it anyway, win or lose, just because you just need to sort of know what went on. So the answer to Rip's question is the ALJ can say, yeah, they can say, I think that your condition is something that will heal up over time. However, if that goes into the decision that the ALJ is denying because under his assumption is that this person's condition will heal up. Well, the ALJ is not a medical doctor. And unless there's evidence that this is a condition that's not going to last 12 months, then, that would be improper. And I think that if the ALJ said that on the record, but it didn't go in the decision, you could probably make an argument that that was, part of his decision because he did talk about it in the actual hearing. So, it's just one of these things where you just have to just kind of read between the lines a little bit here. Okay, now he's talking about this is Joe. Joe is a regular visitor to our live stream. Any frustrations with doctors not performing further tests for a condition? As a patient, have to study his own condition. Seems like it's difficult to sue a doctor. SSA feels like I'm trying hard. So I think, again, what he's getting at is, medical doctors will do tests to a certain degree, but I suspect that insurance drives a lot of it. I mean, I've heard from a lot of clients that, they can't get treatment or a test or a procedure because insurance won't pay for it. And suing a doctor is a whole different story because that's really more state law, but it's hard to do that. Obviously, if the doctor does not do a test that is warranted based on your symptoms, that could be a malpractice issue. But otherwise, this is one of the things that folks applying for disability are sometimes dealing with, is that the doctor is reaching conclusions about their capacity without necessarily having all those tests, which leads me to tell people sometimes, if let's say it's a back issue, I'll tell people, go get your own MRI. I mean, and I don't know if there are, places in Pittsburgh like this, but in Atlanta, you can go to a facility and for $300 get an MRI. And that sometimes can be valuable. I mean, don't you think that would be a useful thing to have, certainly for Social Security and for your doctor even to do? Bottom is, you got to be your own advocate, right? I mean, you can't.
Yeah, that's what I was going to say. Yep. It seems like I've heard that so many times, folks just really have to advocate. And I think even in non-Social Security cases, just in regular life and conversations otherwise, I've just really learned that people have to be an advocate for themselves. Or if you're not feeling well and you have a friend or family member that can be going with you to appointments and advocating with and for you.
Yeah. And I think also, one of the things I've learned, my wife does workers' comp in Georgia. And so, we talk sometimes about, medical treatment. It is amazing how the difference between, the quality of treatment that one can get. I mean, if you have good insurance and you can go to a good, really solid group, let's say orthopedic or neurosurgeon, you might get a very different result than if you go to, a less desirable provider. And you really have to do your own research. Just because your family doctor said, go see Dr. Smith, doesn't mean Dr. Smith is the right person. again, you got to do your own research, because, you know, I sort of grew up thinking, well, a doctor is a doctor, but isn't that the case? It's not really always the case. You know, you can really get yourself stuck with somebody who's not very good, and you go through, and I'm sure you've seen this, people go through multiple surgeries and they end up, you know, with no, you know, in pain management, and there's really nothing that can be done. They're just in chronic pain their whole life, and that's not a good way to be. Not a good way to be.
Which actually, too, I think one thing in terms of Social Security cases to think about, just like you said, how maybe someone would decline a surgery, maybe a second surgery, because they're afraid, like, well, the first one didn't help. Or like recently, I have a client who needed to get some testing done, but their panic attacks kept getting in the way every time they would go try to take the test. And those are really valid reasons, not necessarily that the doctor's not getting the test for you, but that the patient can't get the test, or can't get the surgery, or is deciding to not get the surgery. Judges have to consider the reasons behind the decision, or why the test wasn't there, or why are they missing appointments. Sometimes providers write in there, oh, well, they've been canceling on me. Have your client, or if you're advocating for yourself, explain, well, I did because I was sick at home with a migraine for 3 days, and my appointment was during that 3 days. Kind of try to fill in those blanks instead of letting it look like you just didn't get the test, or you just are deciding not to have surgery to help yourself kind of message.
You know, one question I get, I'll pose it to you, is what is the impact if somebody chooses not to undergo, we'll start with part A surgery, invasive, or what if they refuse to undergo an epidural or something maybe less invasive? What's your take on how Social Security looks at that?
I think it depends on some surrounding factors. For example, let's say they've already had an epidural and it didn't work. Then I think it's very reasonable to accept the explanation of why they didn't want to do it again. Same with surgery, or even sometimes I have clients just explain, hey, I know several people that have had back surgery and they're not any better. I'm afraid. Like, I think actually just expressing your fear is enough of a reasonable answer. And certainly, Social Security can't turn that around and use that evidence saying that you're rejecting treatment or declining treatment, because then I think that would be an appellate ground to argue back, well, no, you're supposed to consider the reason why that they gave you and now have an analysis about it. So I think it kind of, depends on how you can work with the facts around the decision they made.
But I think it's important. You have to give a reason. You can't just say no. You've got to say, I'm concerned about, the idea of going under anesthetic, or I'm concerned about the possible negative outcome, or I'm concerned about the idea of somebody sticking a needle in my back. I don't like needles, or, whatever it may be. But yeah, you got to give a reason. But I believe that there's even a ruling that says that Social Security cannot hold it against you if you refuse to undergo some sort of invasive treatment.
And I think even with pain management, if you have someone who's had a history with an addiction,
good point,
they are now staying away from substances, their treatment's limited. Or if you have someone, say, with like kidney issues or something, that it modifies what medicines they can take or can't take. So there's certainly reasons people choose to not do maybe what the first suggestion was from their doctor. And so, get that documented in the file.
And sometimes doctors are not real happy about that, and it'll go in the record, negatively towards you. But again, you've got to stand your ground on that. Which actually leads me to another question I get frequently. I'll just pose it to you. People will sometimes say, my doctor just won't get involved in disability. It's just not there. They recognize I'm following, but they won't help me at all. What do you tell your clients when they're in that situation?
That's a hard one. I think it depends sometimes on the relationship with your doctor. Let's say it's a doctor that maybe if that's happening, you may not be happy with your treatment relationship just in general. And maybe, it's time to just see if there's someone else who's a better fit for you. I certainly am not suggesting doctor shop to get someone to fill out a form or do something like that, but maybe they're not hearing you, and maybe it's just not the right relationship. So if your insurance or your location allow for it, maybe consider switching providers. If that's not an option, I think the best thing you can do is just keep telling your doctor your symptoms every time you go in and hope they're writing it down.
Yeah.
At least then that can be pointed to in the evidence. Well, this person can't do light work because, as you see, every time they walk into the doctor, they're reporting they've been falling, and kind of work the argument from there.
Yeah, no, I think that, I mean, I tell people, that at least in my experience, with insurance changing and all that, with different insurance coverages changing, it's not at all unusual for someone to see 3 or 4 different doctors within a subspecialty, whether it's the family doctor or the orthopedist or neurosurgeon or psychiatrist. So judges see that all the time. That doesn't really faze them, the idea of some going to different doctors. So yeah, I think if you're getting non-cooperation from your doctor, like you said, I think keep reporting the symptoms so it's in the record, and B, maybe it's time to look for a different doctor. Not all doctors will fill out forms for you, which actually is, something I sense is, 20 years ago, I would tell you I'm looking for a functional capacity evaluation in every case if I can get it. I don't think it's as important anymore. Do you find it as big of a deal as it used to be?
No, I mean, I'm getting less of them,
Mm-hmm.
so I have to make it work without them. So that's where I'm going more to physical exam findings, tenderness to palpation or whatever gait instability, even with the mental health. I'm looking at the mental status evaluation for, flat affect or depressed mood, or if their thought process maybe is kind of not focused. And that's really where I'm starting to try to get meat for argument there, because that's something more that a judge can't really dismiss as easily as, say, an opinion. Because sometimes they say, oh, well, it doesn't match up with the evidence anyway. So
what is your take?
Actually,
yeah.
Sorry to interrupt you.
No, please.
That reminds me, at NOSCR, one of the things that the decision writer had mentioned was when people have doctors who fill out the forms and everything's extreme,
yep,
just really does not have much credibility.
Mm-mm.
They said they rarely saw where they were awarding a case with all these extreme limitations, that having like a marked or 2 marked was always way more credible than just out of the park. Right. You don't need to knock it out of the park.
Right. It was almost like the person who says my pain level's at a 10, 24/7, day after day after day. It's not believable. And I think what you're getting at is that if you look at these functional capacity forms, many times it'll say, I don't know, I can't remember, sometimes it's seldom or occasional, marked, and then extreme. And extreme would be, just complete lack of capacity or complete, level of pain that's beyond the pale. And you don't want like a level, just one after the other extremes. Almost like I've seen people, and I think what they do is they may fill these forms out themselves. They give it to the doctor and they say, that this person's totally non-functional. It isn't credible. It's not believable. So you're better off, saying that, that there's certain things you can do. Look, I remember I had a case, and I've told the story a couple of times. I had a client who had a number of different orthopedic problems when he filed, and one of the issues was his shoulder. And during the hearing, the judge says, well, I see you referenced your shoulder. Is that, tell me about that. He goes, well, Judge, that's not really a problem anymore. It's gotten better. And the judge almost fell off his chair because, nobody does that. And so, if you're believable, if you're like, no, this is not a problem for me anymore. I've gotten past this. I've had a procedure, I've had surgery, I've had medication. If that's the situation, it can really make you look a lot more believable. Just like, again, not having a functional form where everything is marked as extreme, because that just doesn't make a lot of sense. What is your take, and this is a discussion I've had with somebody recently, the importance of age in a disability case? How important is that in your mind when you're looking at cases?
I think it's important. Though if I'm looking at someone with a younger age, then I'm looking to see if it looks like they've tried even a sit-down job. I'm looking to see, certainly there are some diagnoses that come at a younger age, such as schizophrenia. That'll usually present itself like in someone's 20s, under 30 years old. So something like that, or like a traumatic brain injury, maybe because there's been an accident. Those, I think, age isn't a factor. If we're talking about someone maybe who has a few issues, like maybe they're having some back pain and or like POTS, and maybe some fibromyalgia in there. If they're younger and they haven't tried to work at all, I think that's going to be a lot harder to prove they can't do anything at all in the economy, since it's a higher bar with the younger age. So that's where, if someone is younger, I think it's better if they at least try. Then you can show as evidence kind of some trying there. And then too, you know how to articulate a bit better why you can't. So certainly when I'm looking at cases, I always want an older individual because of the grid rules are certainly a helpful tool. And have you noticed that we are getting even older clients now? Like I represent like 62-year-olds who are trying to get the difference. And before, I never would ever have a 50-year-old because they were just being awarded. So yeah, I had a 57-year-old recently. I've just had older clients, and it's amazing that it's hard to try to get them down to sedentary, even though you have two bad knees and they're using a cane. The judge is giving them hypo and has them on their feet.
No, I have a number of people, and this actually is an issue at times where they're getting retirement Social Security and they want to get disability. So basically they're fighting for the difference between the two. And that may be $500 a month, it may be $700, $800, or whatever. You know, if it's $150 a month, I'm probably not going to take that case because there's not really enough in it for me to get involved in it. You know, so I'm looking for typically $500, $600, $700 because, you know, it's probably going to take a couple of years. But again, it's, you know, you don't want to lose money on cases. It's just the reality of the business that we're in. So, you know, that can be a challenge at times. But yeah, I've seen a number of people 63, 64 that are trying to get on, they've taken retirement, they want to get on disability because that'll boost up their retirement to the full retirement amount, which can really make a big difference. But yeah, I've seen much more of that recently. And look, I mean, I tell people, you know, I probably take a harder line on age than you do, in the sense that I think that it's really an important factor. You know, if somebody is 48 or 49, I'm going to typically tell them, try to keep working if you can until you're 50. If you're 53 or whatever, try to get to 55. Something else I'm seeing, I'm not sure if you are, judges, and certainly at the state agency level, they are approving people, but they're changing the onset date. Are you getting that? Where you're getting these onset date changes, and it basically eliminates past due benefits, and nobody's happy.
Yeah, and they're definitely doing it. Like you said, if you have a 53-year-old that applied and has sat now for a year waiting for someone to look at it, or I guess I should say 54 if I'm going to do my math right. And then they award them as of their 55th birthday, which out how long they've been struggling, not having income to pay bills. I mean, yes, they get the ongoing, which is good, but yeah, I have been seeing that. Yeah. And it's hard to make the decision. I will go back and look at evidence and sometimes say, yeah, I can make an argument for that prior time, but you're also risking what you just received.
Yeah. I just had a case I tried last week where they had, you know, cut my client was, I think he was, they proved him as of his 60th birthday. He was 57 and a half at an onset, alleged onset, and they proved him at 60. I know, right. So we appealed it. I mean, and you know, and the risk is that you get a bad judge, a judge who approves very low. We got a good judge, and the judge heard argument, is going to go ahead and approve him. Yeah, like $35,000 or $40,000 in this guy's pocket. And I'm like, that's kind of significant. That's I told him, I said, there's a risk there, but for $30,000, $40,000, it's probably worth it. And the downside would have been that they would have denied him entirely, which I just didn't see that was possible. Of course, I shouldn't say anything's impossible, but it didn't seem very likely. Okay, so all right, so let's go back to Mark is one of my clients, and I know, Mark, I got your email today. I will give you a call to discuss what we want to discuss. And then RD says, what's your opinion about, and I think we talked about this a little bit. It's kind of early to tell. I mean, he comes from the business world. There have been a few interviews I've seen of him, and he says the right things. I mean, certainly I don't think he's as friendly to claimants as Commissioner O'Malley was, but he's mouthing the right words that he wants to be more efficient, to reduce the delays. We will see. We will just see. I know there's a lot of pressure, both from the Congress and from the president, to reduce the number of people that are working for Social Security, reduce the outflow. Again, call me cynical, but I think that, people going through disability, there's no lobby like there's no AARP for disability. That's retirement. And, people on disability are an easy target to go after. If you go after the CDRs, it's hard to get an attorney to handle a CDR because hard to get paid on those. So yeah, it's a challenge. It's definitely a challenge. Which actually leads me to another question. CDRs. I don't know if you guys do them or not, but what are the things that people should do to avoid a review? Are their files coded so that they're likely to get a review? What do you know about CDRs, if anything?
I don't know a ton in terms of the inside and how or when they decide this person's getting checked. Certainly, I would think that you're probably more likely to get checked the younger you are, or if you have impairments that could
get better, or if you're working, or if there's earnings that are showing up.
Yes.
Right?
Yeah.
That's good as well.
Yeah, I would say for sure, if you get any letter from them asking for information, the one thing to not do is ignore
it. Yeah. Yeah. And I think, people say to me, well, if I'm 57, am I going to get reviewed? And I'm like, I don't think you're the target. I think the target is the 35-year-old. But like you said, if you get something from them asking for information, get it back to them timely. And if that means sending it registered mail, do that to make sure they got it, because things get lost in the mail, and that can work to your detriment. All right, Teresa.
Lost at the Social Security office.
Yeah, it can be a black hole. I mean, it is crazy. Stuff gets lost.
And don't stop treating.
Yeah, don't stop treating. Absolutely.
Oh, I'm on my disability. I've been decided disability and stopped going to your doctors. That'll pull your review right there.
Yep, absolutely. And they wouldn't necessarily know until they send you the request for information. Are you still going to the doctor? And if you're not, again, I tell folks, the assumption is if you're not going to the doctor, then there's nothing wrong with you. That's the way Social Security looks at it. So, all right. So Teresa had her hearing on the 24th. A decision it's been sent to the writer. They told me the letter's been sent to the employer. Okay. Who's been working part-time. What does this mean? What do you think? What do you think that, I'm guessing it means they want to see, is the person at SGA level? Are they working at a level where it's over that $1,620 a month level? Because that would just potentially disqualify them. Are you seeing it the same way?
Yeah, it sounds like maybe some type of post-development. Maybe it went to the decision writer, and that would be something where then they said, oh, there's earnings here, we don't know what it is. I have seen where then decision writers have questions then, where the agency, I've learned, does have a process then how they relay those questions from the decision writer to the judge. But certainly earnings is just a technical thing that they would have to get sorted.
Yeah, is that what they call the non-medical review? And people say, I'm getting a non-medical review. They're looking to see, do you have earnings? Because realize that, Social Security, the IRS reports to Social Security, but that's done annually. So let's say that, you get approved in June or July, they need to see, have you been working at all? Because remember, step one of that sequential evaluation process is, are you engaged in SGA? And if you're working, that's potentially an issue. Now, is there a way around it? But could you argue trial work period? Could you argue unsuccessful work attempt? Sure. but if you are working, if they're earnings, they want to know what that all means.
And if you are on benefits and you want to try to work, you absolutely should hook up with an agency. There's different ones depending on where you are that will help you with the trial work period and help you walk through the process of trying to work and reporting it to Social Security and making sure that you keep your benefits safe until you know for sure if you're going to be able to keep it or not.
Yep. Yep. And I think, and that's the other thing about trial work period. I'm actually doing a presentation at a CLE in a couple of weeks about this. You know, there's no real time way to see where you're at. I mean, you're talking about, 9 trial work period months in any 5-year period of time. Well, if you have, 2 or 3 this year, 2 or 3 next year, 2 or 3, you could hit your 9 months and not even know it because there's no place to go to see where you are. And so you got to really keep track of that. And to some degree, it's kind of dangerous to work because if you do that, while it's a good thing, I think, for people to try to work if they can, it's really easy to get, into that overpay or at least to use up your trial work period months without even realizing it. Let's say you take a job where you're paid biweekly and you get 3 pay periods 1 month. That's a potential problem. So a lot of traps if you're not real careful about that. So if there's an agency that can work with you, that's a good thing. All right, so Wu Jae Sung says, does medically induced disability, obviously such as a medically induced mental disorder, okay? I don't think the cause really matters. Do you? I mean, I think it's just a matter of, do you have this disorder? Is it going to last a year, and is it disabling? It doesn't really, the cause seems to be kind of irrelevant. Wouldn't you think?
Completely agree. I mean, if a hangnail is causing you to completely be able to lose use of your hand, it could be a disabling impairment. So or you could have, something that you would think is severe in the sense like you can have diabetes, but that doesn't mean you're disabled. So all of it is about the symptoms and their effect on your functioning despite treatment.
And really, and I'll say this, I say it over and over, you don't win a disability case based on a diagnosis. You win on the functional impact of that condition. But I still say it's got to be, the functional issues have to be somewhat consistent with the severity of that diagnosis. You have a herniated disc and you're saying I've got, radiating pain into my leg and numbness in my foot, makes sense. If you have a mildly bulging disc with no no compression or no stenosis, no nerve root issues, but you're saying I've got numbness in my feet, a lot more difficult to win because it doesn't match up with I think that mental model the judge would have in his or her mind, is my take.
Have you been seeing like any long COVID cases, Jonathan?
I have had a couple of them. I had a couple really interesting ones. I had one with a gentleman recently we got an approval on who was highly educated, PhD level, and was working a job making a lot of money. And he actually got sick from the vaccines. And then he got COVID as well, and that kind of pushed him over the top. I have had several long COVID cases, and the ones I've had have all gotten approved. Now, again, I think that they all have been respiratory issues or cardiac issues. There are other symptoms long COVID can generate, and I think long COVID is one of these things that we don't know a lot about, but so far so good. I'm pretty selective about it, but that's been my experience. What about you?
Same, or chronic fatigue syndrome. Or what I had recently, it was called post-exertional syndrome or dysfunction, which was really interesting. That case was really interesting because this person had a test that actually tested, I guess it's the METS, the measure of energy expended to do an activity. And I learned that if you're going to do a sedentary job, for the average person, you're using 30% of your expended energy. And so for this person, if they would use their 30%, that was the equivalent of sleeping. So for the first time I had of sleeping.
Sleeping, okay. Wow.
So the first time I was like, Judge, this is like objectively, the ruling of less than sedentary.
Wow. That's
So I've never had such great objective evidence like that, but that was a really interesting test. And I'm wondering, as we see more folks with the long COVID stuff, maybe this test will start coming up more and more.
Yeah. Yeah, I remember.
It's a helpful tool.
Yeah, I remember a number of years ago, there was a fellow who had a clinic that would do these METS tests.
Yeah.
And, he was of the opinion this was a much more accurate way to measure, energy and exertional capacity. And he was sort of hoping it would catch on as to become the standard, but he was getting a lot of pushback from, various, orthopedics and physical therapists. But, that actually might be an appropriate test for long COVID, getting a METS
Yeah.
test. So that's a very interesting point there. But yeah, I mean, it's look, things like long COVID. What's drawing a blank now, when you when you get bit by a tick, Lyme disease, another one where, just this crushing fatigue, but
Yeah.
it's really hard to measure, but yet it's really there. And I've had, a couple of Lyme cases where people have gone to Lyme specialists who have those kind of tests, and that's been enough in a couple of those cases. But just like with the long COVID, this fellow was talking about, he went out to, I think it was Arizona or something, or Texas. He found a clinic that did, just a long COVID clinic, and they did all kind of tests, and he got that, report, and it was really, really helpful, and it convinced the judge. So
yeah, I mean, how can you? That's almost like having an MRI.
yeah, no, absolutely, that's absolutely. All right, so Alicia was one of my clients. Just found out my new orthopedic doctor ordered brand new MRIs and X-rays. My insurance will not approve. They want to wait 6 weeks for another type of treatment, showing. Let's see what she finished up. That these tests are even needed. 6 weeks will put me right at a hearing date with little time for a doctor to even assessment. Will look like a refused treatment. No, I don't think that will be the case. And again, this is the classic situation of, insurance calling the shots about medical treatment. And I think judges realize that, could the judge leave the record open for a few weeks to get, updated analysis? Possibly. Do we have enough without that? I'm hoping, I'm starting to work on my pre-hearing work on your case. So hopefully we'll have enough. I think we have a good judge. But yeah, that's a very interesting point. And that is that this is the reality of the life we're in, is that, insurance companies are deciding not to authorize an MRI because they want to see 6 weeks of another, of non-invasive therapy or physical therapy or whatever it may be. Very, very frustrating. Very frustrating.
And I think too, probably judges are experiencing that in their own lives with themselves or family. I'm sure they run into insurance
Yeah.
issues, so they know it's a real
thing.
for people.
Although, years ago, that was a real issue because, you would have judges that were, and I'm thinking 15, 20 years ago, that were probably in their 50s or 60s that had, at the time, really good insurance. And, there was one judge in Atlanta, for example, who had had a couple of back surgeries. This guy was a big golfer, and he'd screwed up his back a couple of times, and he went and he had, significant back surgery, and he's, back playing golf. And so he's looking at my client saying, well, I'm fine. Why are you not fine? And I sort of had this in a nice way say, well, you're not getting the doctor from the Atlanta Falcons. You're getting, different types of, you're giving different levels of doctors. So,
true, and bodies are different.
Yep.
It could work that way, like you're saying, and it could also work the other way. You may end up, we don't know what's going on in a judge's personal life. Maybe they know someone or have seen someone suffer with that impairment, and so they understand, and are hearing things that they've witnessed themselves, and it's ringing true. So yeah, you just don't know. It could go either way.
It could go either way. No, I mean, there was a judge, in Atlanta years ago, who's long since retired, one of these 15% approval rate judges. And I had a case with him with a client who had this swelling. It was just, all over her body, lower extremity, upper extremity. This judge approves this case in about 15 minutes. And I about fell off my chair. I mean, he'd never approved anything, but I guess he had somebody in his family who had significant swelling, and he realized how debilitating that can be when, it's just painful. You're on diuretics, you're having to urinate all the time, and he approved the case. So I'm like, I'm not going to argue with him, but it was just really pretty weird.
The weirdest piece of evidence I had that kind of did that kind of turnaround, the claimant brought to me a picture of them on a workout video case. Because before all this happened, they weren't that fit. And we walked in, they had gotten Lyme's or something strange, and it was a whole different person. And it was like a 3-year difference.
Wow.
And I submitted the picture. I was like, oh my gosh. And the judge like looked at the pictures and was like, oh, okay.
Yep. Now I had a case one time, and I think it was an MS case, and my client was, drove to the hearing. This is when the in-person hearing, and she got stuck in the car in the like where you put your feet. She got stuck in the car, and so I literally had pictures of her. She'd come to my office actually for the pre-hearing. I had pictures of her stuck in the car. I actually took a video of it, of her trying to get her out of the car, and I submitted that video to the to the judge, and he approved it, or she approved it. But it was just like, yeah, sometimes a picture is worth 1,000 words. You never know. It's great. I had here one hearing I had where we literally had to wheel my client in on a stretcher. She was in such bad shape, so she's doing the hearing in a stretcher. It was because she couldn't move. And I'm like, and the judge is like, why did they turn this case down? I'm like, you work for the agency, judge, not me. I can't tell you.
Wait. My colleague Sherry Ann at NOSCR in our presentation actually was saying, as a judge, she had this one case that on paper she just really wasn't seeing, and it was a mental health, like a psychotic kind of case. And they were in the hearing room, and someone had accidentally buzzed in the middle of their hearing, and it triggered this person to thinking that they were watching them, and kind of started the psychotic symptoms. And she, of course, awarded, but she said if that had not happened, wouldn't have realized, because the paper didn't tell the story.
Yeah, and I think that's the one, because I'm doing remote hearings, telephone or video, but certain mental health cases, that's maybe not a bad idea to have an in-person hearing, because the judge will pick up things, or you'll see things happen you might not see otherwise. So here's one of your clients says, Lindsay's my representative. So Sheila is one of your clients.
I hate it.
All right. So Yvette has a question, but Yvette, you didn't give me your question. So I know you have a question, so post it. Okay. So Mr. P, in the process of applying for SSDI, first time applying, but on SSI was just denied for SSI. So, and I don't know, I don't fully understand the question. Let me just make this blanket statement. If you're an SSI, SSDI is not sort of like the next step. You don't graduate from SSI to SSDI. If you're on SSI, that was probably because you didn't have enough earnings record, enough credits for SSDI, so you don't gain those credits being on SSI. So sometimes people call me and say, I'm on SSI, I want to get on SSDI, unless you can argue disabled adult child, or maybe spouse or something, you can't really do that. So I'm not sure if that's what Mr. P is asking, but that is an issue there. And Lindsay's only got a couple more minutes with us because she gets up really early, so we want her to get her sleep. So we're going to go through a couple more, then I'll continue on for another hour or so. But I did want to let everybody know that. Okay, this is a question, and I'll jump to the main issue here. I'm 61 years old. I've been in step 3. If you're not approved in step 3, blah blah blah. Okay, so I saw this someplace on a video, and I don't remember who did it, but all this stuff about step 1, step 2, and step 3, does that mean anything, or is that just a bunch of nothing? I know there is a step 1 where this is where you're at, but step 2 and step 3 is when they're analyzing it, and step 4 is when they made a decision. But those steps could take 2 weeks, or they could take 2 months, or they could take a year and a half. There's nothing that, because you're on step 3 or step 4 or step 2, doesn't mean there's anything that you can draw, any conclusion you can draw about the amount of time it's going to take, right? That
completely agree. Yeah. And I think that's more a tool so folks can see that it's moving through the process.
Yep.
But yeah, you don't know what the time between each step is, unfortunately.
Yep. All right. So I'm going to keep you for a couple more, then I know you want to go. Okay. So this is Texas. Says Texas Sendero, 60 years old, left leg amputated. Would I be fully disabled? could I work? Does it work? Blah, blah, blah. How would I get back support? So I think my feeling is if you've got a leg amputation, you're probably at listing level or pretty close to it. However, if you work and you're over SGA, you're not disabled. You could have both legs amputated, both arms amputated. It sounds ridiculous, but you're not disabled if you can still work. So, you know, medically, you would probably likely be disabled, but if you're working and you're over SGA, then that's a problem, correct? Am I seeing that right?
That is correct. And I think too, the age matters because yes, at 60, maybe the grid rules would apply because that would likely be a good argument to get you down to sedentary. But if you're 30, what I'm looking for are things like, do you have phantom pain? Do you have difficulty with the prosthetic? That they're, you know, it's getting changed. Things like that that would maybe more affect concentration or the ability to keep on a task and persist.
Okay. All right. I'm gonna have, this will be your last question. I'll let you take it. Texas Chick says, hypothetically speaking, of course, if you are 6 credits short of SSDI and mostly been self-employed and have some unfiled tax years, you could file now and pay the 6 credit. Would that be a solution? What's your take on that?
I believe that is. I don't know if you have any. I don't know, like all the tax implications of filing late and maybe any penalties or anything. But yes, that would get.
Yeah. I think you can only go back 3 years. That's the only issue. I think you can only go back 3 years. And of course, you know, you can get up to 4 credits in a year. So if you have 3 years of unfiled that you can now file and get those credits, you know, assuming you have enough earnings to earn a credit. And by the way, the amount that you need for a credit is not the same as what it takes for SGA or what it takes for trial work period. So I've got a whole page on my website about that. But yeah, you can quote unquote buy credits by changing your tax return. I've even had people do it where, let's say, a husband and wife were working together. All the earnings came in under, let's say, husband's social security number. However, wife was working and she didn't have enough credits. And I said, well, you know, talk to your CPA about refiling your taxes to split up those earnings so that some of them go to her, some of them go to him. So that's also a way to do it. So that's more of a tax question. But the answer is yes, you can, you know, as long as it's legal and appropriate to do so, you can change your earnings credits by amending your tax returns. So, all right. Anything else you want? I know you want to run. Anything else comes to mind that this is triggered, or anything else that you want people to know?
I wanted to say that you can now file your SSI application online.
Okay. Yeah, for a long time you couldn't, which made no sense. Right.
Yeah, before it was just the SSD, and then you'd have to call. So I think Social Security might be moving to where they don't want to be processing that or using the staffing for that. Instead, have you do it online. Yeah. So I think that's a nice.
That's a good. You're saying just one more question. Your sense. Do you? I think I have an opinion on this. Do you see remote hearings as a permanent feature of disability work now, the telephone and video? Yeah, I think so too.
Yeah.
Do you like them?
Staff.
Yeah. What do you like them? Do you have a preference? Live, video, telephone?
I think I haven't necessarily seen a difference in outcome. If it is something that I think, you know, this would be helpful for the judge to see you, I think teams can do it. What I have seen is that it's a lot easier on my clients.
Yeah.
They don't need to figure out money for gas. They don't need to figure out a ride, parking,
yeah.
Get in or sometimes the ID, if their driver's license expired because they were no longer driving. Right. If the hearing office is in the federal building and have ID.
You have to have an ID. That's right.
Yeah, so I have found that it's easier on claimants, and you can be in your recliner, you can be in your soft clothes. Like, I mean, the whole point of the program is you don't feel good.
Yeah, exactly. And I think judges like it too. I mean, I think that you know, the idea of being in a small room with a bunch of strangers day after day, you know, hacking and coughing on you. You know, look, I remember going to those hearing offices in Atlanta, North Atlanta, and they would be, you know, maybe 30 or 40 people in there. and there'd be little kids running around. And I mean, the chairs were, my wife and I used to joke that I had my hearing suits because, the chairs were they were fabric for some reason, and they were just disgusting. I mean, because, they just didn't clean them, and it was just, it was not
I've
good.
had hearings canceled back then because someone had MRSA, and it was very protocol. If someone had MRSA, they were not coming in that often.
Right. Yeah, it was in, look, I remember the day, I mean, this may be even before your time, but I mean, before they had electronic records, you would have to physically go down to the hearing office, check out this big yellow file, this thick, and sit there with a notepad and review it, check them out, and sit there for 3 or 4 hours in the hearing office, on your lap. There wouldn't necessarily be a room to go to. So it's a lot easier now because it's all electronic. So
yeah, I remember the change being scary because yes, I've spent many afternoons photocopying the file and then wheeling them out. But yeah, the electronic really has been a nice change.
Lindsay, tell people if they want to get a hold of you, what's your firm's website, how they get a hold of you, if they have any questions.
So my firm is Osterhout Berger Daly. We have offices in Pittsburgh, Chicago, and Jacksonville, Florida. And along with disability, we also do long-term disability cases. We help with IEPs. If you have a child who you would like help reviewing your IEP, we certainly have services for that. And our website is obd.law.
That's, for those, maybe people think it's supposed to be .com, but it's actually .law, obd.law. And again, I can personally attest to the quality of work that Osterhout Berger Daly does, because I work with them on a frequent basis. So, if you have something that they handle, then you would not be making a mistake doing so. So very good. Lindsay, as always, a pleasure. I really appreciate your time, and I wish you the best. And I'm sure we'll be in touch very soon.
Thanks so much. It was so good to see you again tonight.
Very good. Okay, so I'm going to continue. I'm going to let Lindsay go, but thanks again for your time, and we'll go ahead and continue. So, okay, so let's go back here. Had a couple of questions, and we'll just kind of follow up with this. Lulu had asked a question about what's the step she was in. She's 60 years old and has left. I'm sorry, this one here. Not approved step 3. Does automatically mean your case goes to step 4? Yeah, I mean, I think it does. I mean, that's the whole point, is it goes, it's not really, I think step 3 is just, it's where the process is. And step 4 is when it's, a decision's been made. And the grid rules can help at the initial or reconsideration level. So the steps are just the process of the case being processed through the system, approved or not approved. It's just it's a timeline. It's the best way to put it. I think working 35 years always helps, in the sense that Social Security recognizes that people with a long, consistent work history, the last thing they want to be doing is filing for disability. And, something I always tell my clients is, let the judge know how difficult and frustrating it is for you to have to pursue the disability route. The idea of labeling yourself as disabled is really a tough thing. Let the judge know that. I mean, judges are human beings. And, I'm a big believer, as you all know, about having a narrative, telling a story. And part of that story is you are a reluctant claimant. You don't want to be there, as opposed to someone who's decided that they're disabled, they've given up. Judges pick up on that. They call, I call it an attitude of entitlement. Don't want to have that. So you definitely want to make sure that you are, you're definitely presenting yourself as a person who does not want to be disabled and would go back to work tomorrow if you possibly could. Okay. We have No Sky, who is here. Good to see him. Andrea, you've got it. I appreciate you. Thank you for your confidence in us. I'm glad that you find the live streams helpful, and I'm glad, I'm going to have next week, I'm going to have Adriana De La Torre on again to talk about some things going on in district court. And we're going to try to get Sherry Ann on, who's a former judge who works with Lindsay. And I've been in a couple of her presentations, very, very sharp. And again, I've got a judge I still want to get on who's agreed to come on. I just got to arrange for it. So we'll have some more stuff coming up. So Wu Jae Sung, I think Wu Jae had asked about medically induced disability, is that something okay? I think whether it's SSI or SSDI, the standard is the same, meaning that the Social Security defines disability in terms of how your medical issue prevents you from engaging in substantial gainful activity. If you're pursuing SSDI, that means you've got enough earnings credits to qualify for SSDI, and the amount that you'll get is probably going to be a little bit higher. SSI is a means-tested program, meaning that you don't have enough credits, but you still meet the definition of disability, and it's subject to offsets like household income, support from family and friends, or any kind of assets. But the definition of disability, the standard, is exactly the same. Okay. Afsena, who's one of my clients here. Good to see you. Good evening to you. Crypto wealth. Actually bought a little crypto the other day. I never delved into that, but I bought just a tiny little bit. You never know. We'll see what happens. The problem with crypto is nobody knows what it is. It's just sort of this made up kind of currency. But, some people in the know think that it will be replacing the dollar as the world's currency. It is on something called the blockchain, which is the security part of it, I guess. But it's kind of interesting because, certainly if you'd bought Bitcoin when it was at 15 cents and you bought a lot of it, you'd be quite wealthy right now. So I didn't buy Bitcoin, but I see crypto wealth. So we'll see what happens. Actually, one of my clients suggested it to me, and I did a little research and said, okay, I'll put a tiny little bit of money in it, and we'll see what happens. My kids think it's cool that I own some crypto, so that's part of it too. All right, 57 years old, work a sedentary job. About 2 weeks ago, I was diagnosed with myasthenia gravis, I believe, unable to work. My FMLA runs out in 10 weeks. Okay, so, part of the definition of disability is not being able to engage in substantial gainful activity because of a diagnosed medical condition, but that condition has to be something that has lasted or is expected to last 12 consecutive months. So question one is, are you likely to be out for 12 months? Is there any kind of treatment that might restore your function before a year? I don't know. And again, maybe the doctors don't even know that. The corollary to that is Social Security is going to see it and say, well, he's only been out of work for 2 weeks. We don't know if he's going to be out of work for a year. So, given that your condition is one that is not, it's only been a couple of weeks, it's probably early for Social Security to conclude you're likely to be out for a full 12 months. So my guess would be if you applied, you'd probably be denied. However, since the cases take so long, by the time you got to a hearing, it'll be a year and a half from now, in which case you either have been out for a year and you've got medical support or you aren't. So my thought would be if there's a reasonable expectation you could be out for a year and you've got a condition that is disabling, it's limiting you from performing even something simple and sedentary, go ahead and apply. No reason not to. It'll take 8 or 9 months to get a decision. So now you're already 9 or 10 months in. You file your recon, you'll be clearly over the year. And by the time you got to a hearing, it'll be, probably 2 years from now. The problem, of course, is how do you survive during that 2-year period of time? That's a different issue. But my thought would be 57 years old, that helps you a lot. You've had sedentary work, so it's not like there's, past work would not be light because it's sedentary, although we don't know what you did before the past 2.5 years. It's a 5-year look back. I'd probably tell you to go ahead and apply and then see what the treatment looks like. And of course, try to get better, try to get to the point you could be back in the workforce. Always better to be working. You'll make more money. It's a sure thing. And you'll feel better in terms of interacting with other people. But, if you feel like there's a reasonable chance you won't be able to go back to work, then go ahead and apply. RB, my recon just moved from the SSA account after 6 months. The rep has mailed out an adult function report. This feels like a repeat of initial. Any hope of recon with another ADL? Realistically, no. I mean, in fact, I've been just looking at some files I'm doing pre-hearings on, and you see the adult function report at initial. You see it at recon. They'll look at it. but recon has got the lowest, percentage wise, it's going to be pretty low. So I think it's pretty unlikely you'll be approved at recon. You never know. You got to go through it. But, unless there's something significantly different, probably not. I just, to be honest with you, hate to tell you that, but that's just the reality of it. Recon is kind of a waste of time, in my opinion. Trish, hello, Trish. How are you doing? John Hodgson, I'm 60. My SSA letter said there's no need to investigate my case. Been an SSDI for 10 years. When I turned 62 and transferred to regular payment, still, I think you don't transfer till 65 or 66. I don't think it's at 62. I think you stay on disability till full retirement age, if I'm not mistaken. You can double check that, but I think that's the way it works. Okay. Missouri DDS did Shub right, 70 working days and approved. Hey, that's awesome. It does happen. I've had a number of cases approved early, and that's great. If they do their job and you get approved early, good for you. That's great. Good to hear. I always like to hear that. All right, RB is giving me some, this is the person whose case just moved to recon, is giving me a couple of emojis, okay? KU Thunder, hello, Jonathan and Lindsay. Lindsay Lindsay told me she gets up at 5 a.m, so she needed to get to sleep. Yeah, she's Lindsay and I have done a couple of CLEs together. She's very, very capable attorney, and like I said, her firm, everybody in her firm has always been very, very willing to share their knowledge, and it's great to have people like that to run things best. And I use Carl, her husband. I have him review almost all of my unfavorable decisions, and if he likes it, we'll co-counsel on the appeal. So I think they're great. Okay, yeah, I think so. Deb is telling me the same thing that I thought, is it changes to full retirement at or your full retirement amount, or your status goes from disability to retirement Social Security at full retirement age, not at 62. Okay. Brian's had 2 CDRs. Brian has ankylosing spondylitis, which is a autoimmune disease where these bones in the spine fuse, not because you want them to fuse, they just fuse sort of naturally. And since it's not an operative fusion, it doesn't always give the person, they lose function. That's called ankylosing spondylitis. And so, it can be a very debilitating condition. And so, his point is that he's had 35 years of this, and, he's not going to get better. It doesn't spontaneously improve. So unless Brian goes to work and they see earnings, or there's some major medical breakthrough, you're not going to find yourself removed. Theoretically. Now, again, I never say never, because Social Security, you never know what they'll do, but it seems pretty unlikely. It's pretty unlikely. Actually, John, technically, if you decided to go for early retirement at 62, it would reduce your benefit. Why would you do that? It makes no sense. Just stay on disability until 65 or 66, and then it automatically converts. There's no logical reason in my mind to convert it to early retirement. If you did it because you wanted to work, at 62, if you work after a certain amount, they start reducing your retirement benefit, whereas at 65 or 66, full retirement, you can work and it doesn't affect your benefits. So no reason in my mind, unless I'm missing something, why you'd want to take retirement early at 62 if you're on disability, unless you have, gone back to. But again, going back to work you're just going to see an offset there. Brian asked, can they access your Medicare, Medicaid records? Wouldn't it be much easier if you got 30 years of memory? Again, they have a file on you. They may send you an 827, which is a medical authorization. They may want to get more records from you. But there's no central repository of records. Assuming you're on disability, they've already got part of the file. They can get more of it. But the reality is, I don't expect there's anything in your file that's going to show that there's been significant improvements. I don't think there's going to be an issue there. Cynthia this is going back to Lindsay and my discussion about back injections. Not comfortable with back injections, and I hear you. I don't know that I'd want somebody sticking a needle in my spine. I do get cortisone shots in both hands. With assert my case, recent spinal stenosis, added the list after MRIs. So, as we talked about earlier, I don't know if you caught that part of it, Cynthia, but there's a ruling, which is a Social Security, like a precedent, is maybe that's the way to look at it, that says that if you decline recommended medical treatment, but you have a good reason for it, that will not be held against you. So, for example, if you say, I'm choosing not to have epidurals or facet injections or radiofrequency ablation because I'm concerned about, negative side effects, that's perfectly legitimate. And, if a judge was to deny you because you refused even a minimally invasive procedure, I think that would be appealable, because they can't, sticking a needle in your spine, there is risk there. I don't care if it's a 3% chance, there is risk there. And any procedure, especially with your spine, there is risk there. So I don't believe that would be held against you. Now, whether a judge would hold it against you and cover his tracks on a record, can't tell you, but theoretically should not. Okay. Madeline from my office says, good evening to everybody. Hello, Madeline. Madeline in Oklahoma, beautiful Oklahoma. Cindy G, good morning, in Philadelphia, maybe Philadelphia. Oh, in the Philippines. Okay, Cindy, you must be in the Philippines. So I hope you are having nice weather there. I hope it's good. I had a client a number of years ago in Vietnam, and we did his hearing. He was an expat. He'd moved there because the cost of living was cheaper. And I remember it was 8 o'clock in the morning was our hearing. It was 8 p.m. in Vietnam, and we did the hearing, and he was approved, and all was good. But it was just, I remember it was like literally a 12-hour difference, which is kind of crazy. But I think he had to go, if I'm not mistaken, every certain amount of time he had to come back to the States to preserve his citizenship or something, or his eligibility. So that was, I know, a bit of an issue. Brian says, if your doctor is not, your advocate is find time to find another doctor. Yeah, I don't disagree. I mean, again, if the doctor is certainly working against you, I would definitely tell you that. But as we talked about, sometimes it's hard to find another doctor, finding a doctor who takes your insurance, finding a doctor who will work with you, but yeah, if your doctor won't help you, that's definitely something to look at. Who is the guest? Pricey Joy, the guest was Lindsay Osterhout, and Lindsay is a lawyer, a partner at a firm called Osterhout Berger Daly out of Pittsburgh. And like me, she does cases all over. And her firm, as I mentioned, has been very, very kind to me over the years. And we've co-counseled a number of cases together. And so, like I said, Lindsay and I have done CLEs together. So I always like to have her on because it's, it's just nice. It's good to have friends in this business, and she's one. So Mr. P, switch doctors and you get even more sick. Okay. And again, that's going to happen sometimes. Sometimes, a doctor will try different treatment and it will not work out. Okay. I often worry my doctor will feel like I'm better than I am. I don't want to admit defeat. Always keep your doctor's notes, what they are saying. And I think that the point you're making is actually a really good one. And that is, a doctor inherently is treating you to make you better, right? I mean, that's why you go to the doctor. And so for a doctor to put on his or her notes that you are not getting better is reflective of the effectiveness of their treatment, not just the quality, but the effectiveness. You go to a surgeon and you have surgery and it doesn't work, is the surgeon going to really want to put that the surgery failed? So sometimes it can be helpful to go to a different doctor after a procedure or after treatment to see what another pair of eyes thinks about all this. And, you're not crazy. You're really not feeling better. So that's just something to be aware of, that the doctor many times has a vested interest in, showing that you are doing better. And sometimes you're not doing better. Sometimes, it just depends. But that is definitely an issue there. Mr. P has auditory hallucinations. Mind is erect, living alone for 12 years. And auditory hallucinations obviously can be very distracting because you don't always know what's real and what's not real, and realize that disability, the definition of disability is being able to function reliably at a job. And if you're being interrupted by sound, by voices and things like that, you can't control, that can be very disabling. So I've won a number of cases from folks who are have audio hallucinations. It's very hard to treat because you realize that when you go get treatment, psychotropic medications, they may work for a while, but then they start losing effectiveness and the problems come back. Yes, Lindsay is an attorney, as Deb says. Yes, she is an attorney. Okay. Cynthia, somebody, KU Thunder says he's never seen somebody spell Cynthia with a C-I-N. Okay, instead of C-Y-N. Okay, very good. Okay, so you Google Lindsay. Very good. Okay. All right. Randy, easy with the old comments. I resemble those remarks. Okay. Well, Randy, I resemble them too. So, being in your 60s certainly helps. When you're applying for disability, Social Security does realize that it's much more difficult to re-enter the workforce when you are, in your 60s and your late 50s, and that helps you in the Social Security world. But yes, they call it, closely approaching advanced age, which is not a great thing to hear. Nobody wants to hear that, but Social Security is not politically correct, so they'll tell you you're closely approaching advanced age. Kelly says that absolutely like that button. That would be great. Leave me a review, as you see here. The more people that subscribe, the more people that like it, the better, more I'm shown. And that's helpful to me, which I really appreciate. Cindy with a CY. So I got a CI and a CY. Is documentation from doctors in the Philippines allowed in court? Yeah, it is. I mean, I've had cases where I had a client recently, case that we won, and the gentleman's wife was on last week. They had lived in Mexico because the cost of living was cheaper, and they had gone to doctors in Mexico, and those records were part of the file, and they were recognized by Social Security. I've had cases where, records from, any number of places, in Asia. I think I had some from Israel one time that we had to get translated, but that as long as the translation is accurate, judges will accept it. It can be a little harder to read, and certainly if you have records in French or German, you'll want to get them translated. Probably have somebody who does a translation, certify that they are an official translator. But yeah, absolutely, you can do that. It does not matter. And we're talking about audio hallucinations, but yes, there are people who have them, and it can be very, very debilitating. That is Carl is her husband. Lindsay's husband is Carl, and so it's Osterhout Berger, and Eric Berger is one of their partners, and Eric's in Jacksonville, and the Daily, they joined up with the Daily law firm out of Chicago. So they've got offices in Pittsburgh, Chicago, and in Jacksonville. But again, everybody's remote now, so it doesn't really matter. But you couldn't be in business with your father. Okay, Carl is her husband. He's really smart guy and very generous with his time and his expertise. Okay. They have biotech injected in your bloodstream. And again, I'm not sure what that means, but okay. John Hodgson says heart meds many times, like diuretics, like Lasix. There's other ones as well that cause frequent urination. And I've won a lot of cases. I had one just a couple of days ago on Tuesday where my clients, because of heart issues, was taking diuretics, and was having to urinate every 30 to 45 minutes. And the judge asked the vocational witness, if this person has to take an unscheduled break for urination 5 to 7 minutes every 30 to 45 minutes, what does that mean? Well, that's excessive, said the VE, and the case will be approved. Okay. Okay. What are the odds of someone winning back Social Security disability if they were getting it from 3 to 27, only cut off because they're incarcerated? I think it's going to really depend on the medical evidence. The incarceration doesn't make you less disabled, it just wouldn't be eligible for payments. So if there is a condition that is lifelong, which this would appear to be, I think if you reapplied, then you should be put back on. But again, that's what should happen. That's what should happen. Okay. Okay, right. And I think this is going back to what I said about diagnosis versus the functional issues. And that's correct. Functional issues are the key to win. Okay, so Wu-Jay Sung says body movements are not your own. So again, if there's something going on where you are, because of treatment, you're having unusual movements, your loss of control of your body, that theoretically would be disabling. Christina says hello. Hello, Christina is one of my regulars. Good to see you. You ate a totally okay. And again, would you? I don't know. I don't want to necessarily get into some of the weeds here, but obviously, it appears there's some things going on that very well may be disabling for you. So if you've not applied, I think you should look at doing so. St. Louis, one of my regulars. What is the turnaround in getting a decision after a hearing where the writers impacted by the job cuts? I think that the writers, like everybody at Social Security, were given an option to take an early buyout. So I think there are probably fewer of them. I'm finding it's anywhere from 10 days to 2 months is sort of what I'm seeing. And it just depends on the writer. It depends on, pardon me, I apologize for that. Just had a yawn there. It depends on the writer. It depends on how busy the judge is, because the judge has to sign off on it. But again, my experience, 10 days to 2 months. An eating disorder, again, may or may not be disabling on its own, but combined with other things certainly could be. Okay, I think we already talked about that. Okay. Mr. P has to reapply. Yes, there will be Cassandra, there will be a recording. It'll be on the YouTube channel. If you're not, just go to Ginsberg SSD, or I think it's, I don't remember what my YouTube handle is, maybe @SSD attorney or something like that. Just search for my name. It'll be on the YouTube channel. A recording of this, or a copy of this will be posted. Every week's recording is posted, so it's all on the YouTube channel, so go there. Okay. Hello, Blocks Fruit Picture. Okay. I like the story. Yeah, sometimes when lawyers get together, we start going into old war stories and talk about crazy stuff that's happened. One story I didn't even share, and I'll tell you all about this, was I had a case. This is downtown Atlanta many, many years ago. And I had a client who was a brittle diabetic. And this guy was probably in his late 30s. He was stocky. He was probably 5'7", 230 pounds, had been kind of a weightlifter type, but he was a brittle diabetic. And the problem was he didn't have money for insulin. And so he was in bad shape, really bad shape. And he started to have organ failure. And unfortunately, he subsequently literally died of this, and not too long after we got our approval. But because he couldn't afford insulin, he was in organ failure. I think his kidneys and his liver was shutting down. And we were in the hearing, and you could sort of tell, was not doing very well. All of a sudden, the fire alarm goes off. And of course, you couldn't use elevators. And the hearing room was like on the 7th floor. So I'm like, we got to, I didn't know if it was a false alarm or not. So, the judge is sitting, and the judge at the time was probably in his late 70s, Judge Bell, who was a really good guy, late 70s, I'm guessing, maybe mid 70s. So Judge Bell and I, sort of taking this guy who was, like I said, probably 250 pounds and stocky, we're kind of guiding him down the stairs. We put him in a chair, rolled him to the stairwell, and then we're like trying to, keep him from tumbling down the stairs, and he's trying his best. And we go down about 2 flights, and the judge looks at me and goes, I'm going to approve the case. Like, I would hope so, because you can see how bad off he was. And like I said, unfortunately, nice guy, he passed away because he couldn't afford medicine. It was terrible. It was just terrible. But that was another war story. But yeah, you do this long enough, and you all kind of crazy stuff, like the one about the lady got brought in on the stretcher, and just all kind of crazy stuff. It just happens. Okay. Maybe the psychotic is faking problems. Okay. And again, that's something, I will tell you that if you have psychotic features like hallucinations, obviously it is not something you can take an MRI of an image of. So you really have to have ongoing treatment where a doctor believes you're telling the truth. And Lindsay, we talked about it, that sometimes an in-person hearing can be helpful for that. I remember I had a case, another war story here. Young lady, she was in her 20s. She was in her late 20s. And her mother was very concerned about her because she was just, she wouldn't take her meds. She was really in a bad way. And she would like disappear for weeks at a time. And so we had a hearing, and this poor young lady smelled. I mean, she hadn't bathed in days, it appeared. And, it was at the hearing, it wasn't even a question. You could smell her. And I think the judge picked up on that. I know the judge picked up on that and approved her. So yeah, there are times when, a in-person hearing can be helpful. And sometimes mental health cases, it really can be, because the judge will get a sense of that, or maybe a video hearing, the judge will get a sense of that. So Andy Gerby, on my Social Security account, it shows I get about $2,400 a month. Do you think that's roughly to get approved? Or can be different? My monthly earnings plus about 16. I would, if it says it on your My Social Security statement, I think that's probably pretty accurate. I would think that's pretty accurate. I don't know why it wouldn't be. Now, there may be a Medicare premium that may reduce it a little bit, but yeah, I think that's pretty accurate. Okay, Precious has a good question. My date last was September 20, days last work was March of 20. If you can prove going back to 2020 that you became disabled before September 30th of 2020, so you weren't working, which is good. So you've got to show that between the time you stopped working and the time your date last insured, your condition deteriorated to the point where you would not have been able to work, and it continues to this day. But yes, it is possible. It is getting more difficult because now 5 years have passed. So getting records going back 5 years can be a challenge. But if you can do that, theoretically, you could win SSDI. I've got a case, in fact, coming up. I was just doing pre-hearing work on it before I started the live stream, where my client's date last insured was like 2018. And, it's just because this person had some severe gastrointestinal issues that are well documented going back to before 2018. I don't normally take cases like that, but this one I felt like we had a shot at it. So I was wondering, if someone's wife has an overpayment, can the husband take his Social Security check and send it back directly back to start paying off? I wouldn't just send the check back. I would deposit the check and then use the money to repay, if you want to, the overpayment. So, but I wouldn't just send a check back. I would deposit it because it's your money, if you're as the husband, and so they send them back money. They don't know or care where it comes from, but I wouldn't just send them back your check. That's going to confuse things. Jen from Nebraska, my main paralegal. How are you doing, Jen? Hope you're doing okay. Cynthia, you are very welcome. I'm hoping we will achieve. I've been on a streak. I got to tell you, I don't want to jinx myself, but I've had like 5 or 6 in a row approvals. Just they're coming in. Not that that I've tried a bunch of cases, but just getting a bunch of approvals, which is always a good thing. Had one denial, but a bunch of approvals. So that's always a nice thing. Again, good cases, good prep. I mean, Jen and her team does a really good job, and nothing better. Okay, right. So if you're not working now, you could theoretically qualify. That's correct. Right. So if this is the person who's talking about being incarcerated. So, if it was stopped because you were incarcerated for a year, you reapply, you've got to show that you remain disabled. And, the other question, I think, if I'm not mistaken, your date less insured is suspended while you're on benefits, but that's the other question. Make sure you have credits there. Okay. Golfer Pro 12. My wife's attorney will have each of her 2 doctor specialists write detailed professional reports stating why she's disabled for upcoming hearing. Is this something you do too? If you can get it, absolutely. If you can get narrative reports from specialists, that goes a long way. A functional capacity form from a specialist, that can go a long way. Even treatment records from the specialist discussing specific functional limitations. The more you can, if you think about it, disability is about someone's functional capacity. Medical records are about your medical condition. If you can have a doctor translate, that's the way I can really describe it, translate the medical issues into very specific work limitations on sitting, standing, walking, kneeling, crouching, crawling, stooping, lifting, carrying, whatever those may be, mental, focus, concentration, maintaining pace, maintaining attention, behaving in an emotionally stable manner. If you can have your doctor translate the medical issues into specific work limitations that are at a significant level, you win. That's what you want to do. And that's what looks like your wife's attorney is doing. But that makes perfect sense to me. All right. Follow the Messiah. I don't want to, Medicare is not my area, and I don't want to talk about Medicare because I don't know enough about it. There are people who know a lot more about Medicare than me, and I would just have to defer to those folks. RD is 56 with a June 24 onset date. My urologist told me I'll need mesh removal surgery. Will it hurt my case if I didn't know the surgery? No, it will not. You have a surgical order. If you choose not to undergo the surgery because you are concerned about negative side effects, you're concerned about, possible bad reaction, you're concerned about anesthetic, perfectly fine. So no requirement you have the surgery. Now, after you have the surgery, Social Security may, have that in their system, and they may ask you to, reveal information about your condition post-surgery as part of a continuing review. So that could happen, but beforehand, no. How is live videos for disability hearings? Again, the default now is virtual hearings, telephone or video. They use Microsoft Teams. I personally, suggest telephone hearings because there's less to go wrong technically. The issue with the Microsoft Teams hearings is that I'd say 10% of the time, maybe 15%, there's some sort of a technical glitch where somebody isn't showing up, or the connection is not good. To do video, you have to have a much more stable connection. And so, if you don't have a really stable connection, or the judge doesn't, or I don't, I usually do, but, it could be an issue. So, if you feel like you want to see the judge and the judge to see you, there's nothing wrong with it. But, they work great. Judges are fine with it. But I don't know that a judge really has a preference between a telephone hearing or a video hearing. I don't think it makes any difference to them. Brian has a driver's license. And again, that is a functional element. Now, you would have to testify the reason you have not had it is because the ankylosing spondylitis or whatever the condition is, you cannot drive. That is a functional issue, and that on its face will eliminate jobs that require driving as part of the job, forklift drivers, couriers, things like that. So it does have an impact. Okay, John C. I know someone who has a case in which their SSI income and the children under 18, and they used to receive income for them, they were cut off. It's going to just depend, on why they cut them off. I mean, if the children are getting benefits as auxiliaries, and again, that's only going to be an SSDI case. But if the children are receiving benefits as an auxiliary and the underlying claimant gets cut off, then the auxiliaries get cut off as well. So Cindy says, thank you. You're welcome, Cindy. Thank you, Blocks Fruit. Okay. Chronic kidney disease under dialysis. That's a winning case. I will tell you that, in fact, I looked at this from somebody who had emailed me about that. And I just said, you look at the listing, if you're on dialysis, you're by definition disabled. Excuse me, you meet the listing. So that's a winning case. Okay, Texas Chick, thank you for the answer. Carrie, how are you doing, Carrie? In Virginia, new SSDI recipients are not losing Medicaid as long as they're entitled to. I believe you mean SSI. So if you are getting, let's say that the 5-month waiting period for your SSDI, but you're eligible for SSI during that 5-month period, that's what would preserve your Medicaid. There's an adult medically needy Medicaid program, but yeah, if you get SSI even $1, then you would preserve your Medicaid. Now, I don't know much about the other Medicaid issues, but that part of it, I do. I was terribly sorry about that. Didn't even play tennis today. Did lift some weights, but I didn't even play tennis today, so I don't know why I'm so tired here. But yeah, that's the answer there. Autumn Scorpio, thank you for the much needed info. You're welcome. Yeah, you can look, Brian, that there's a table, and I don't remember what it is. I think 66, or I think it changes monthly after a certain point. Let's see, how can I get full benefits, but I'm also paying Medicare premiums in full amount, which is $1,100. I think as long as you're paying Medicare premiums, you don't. What you might want to look at is, are there options other than full Medicare? And that would be something that a Medicare person would be able to tell you. I know my buddy Chad Brown, who's a disability attorney, and I was just on his podcast earlier today. He has an insurance agency, and he may be, let me see if I can get the link for you. Okay, the insurance agency for Chad is here. I'll put the, and he does Medicare. It's called cbigcares.com. I will put this in the notes here. So if you want to check with Chad about Medicare issues, that's how to do it. CBIG Cares is the website. CBig Cares. That's Chad Brown is the person, but he is a disability attorney who also has a Medicare agency, insurance agency. How does crypto well, it only if your assets go above, I think it's $1,000 limit. So if you buy crypto and it takes off and it becomes worth a lot of money, that's a problem. But as long as you've got $100 of crypto, that's not going to make a difference. But you got to keep an eye on the assets. Long day. Great questions. Speak soon. Okay. Full retirement is 67. Crypto says, thank you for taking my question. You are very welcome. Thank you for coming on. Okay. I did thank you. Okay. Now we're talking, I don't know. Okay. Okay. I didn't tell you I'm pursuing a physics degree. Expect graduation at 62. I invented home, but getting a degree is making models and presenting the idea. Well, again, getting a physics degree could be considered substantial gainful activity. So, if you're in school, even though if you're not earning money, it takes a lot of brain power to earn a physics degree. And so Social Security would likely conclude if you can handle school to get a physics degree, and then you're going to get you're going to be an inventor, that starts to look like substantial gainful activity. that works against you being considered disabled. That may be, again, the whole idea of taking retirement early. But like I said, you got to be careful about what you might be able to earn, because that could, it's very, look at the rules about how much you can earn on early retirement Social Security. That's what I would tell you to do. But that's very interesting. I'd be interested to know, maybe John tells what type of things you're inventing. That's really very interesting. That's, I always found inventors fascinating, just because there's so much, you have to be so creative yet still structured. It's just really, really neat. So good for you. Good for you on that. Well, again, Deb, it depends on how much, how much money you have in crypto. I mean, if you're buying a crypto for, $1 and you buy, 10 coins, $10, it's not a problem. But if you're buying thousands, yes, it would be a problem. Jeff says his recent MRI shows moderate to severe formal stenosis. That could be enough to get you past the, to meet the profile. It depends kind of on how old you are and how badly this, what the MRI really says about, the effect of the stenosis. But, moderate to severe is significant, and that would probably be consistent with a, fairly significant pathology. So Brian said his mother died, left you some money, then cut off your SSI, which is because the asset part. Now they want you to pay back the last year. Sometimes people, what they'll do is they'll contact an estate attorney and set up a trust, and that may be able to avoid that sort of thing. I don't know if it's too late to do that now, but if you're on SSI and you expect to receive an inheritance, it's worth looking into, is there a way to have that money not be your money? And I'm not an estate planning attorney, but I would just tell you to look into that. And Brian's right. In SSDI, you can have unlimited assets, but SSI is a problem. And I think Deb is right on target. That's exactly what I think the rules are. Okay, we got about 10 minutes to go here. Precious, I have a question. My answer was, okay. So I think we've already answered that question. If you can show your disability began between March and September is really what it boils down to. If you get approved for SSDI at 60, it's indefinite unless they move to evaluate you. At 60, you're not in their target demographic to go after. You're going to be on retirement soon. They're going after the 35, 40-year-old. But if you show work or if there's medical improvement, they could review you, but it's less likely. Okay. I think Deb is correct. I agree. With cuts, yeah, I think that's probably right as well. All right, Texas Chick says, definitely get a second opinion on back surgeries. My first surgeon did not do mine correctly. Second surgery had to correct it. Yeah, you got to really be an advocate in this regard. Cross-examine a vocational expert's lawyer, last words, mental illness. Well, I mean, the vocational expert is only answering questions based on what the judge is asked. Now, there is a line of thought that you can challenge the vocational witnesses' numbers. And just briefly, how that works is there's a resource out there called the DOT, or Dictionary of Occupational Titles. Go to occupationalinfo.org. And that's what Social Security used for years and years, and they still use it to some degree. The problem is the DOT was last updated in the 1980s and 1990s. So a lot of the classifications and descriptions of jobs in the DOT, which includes every job that theoretically exists, is terribly outdated. So, now a lot of jobs are done using computers. Well, in 1990, they were not. You operate a copy machine, you got to operate a scanner. There's just a lot of things. There are jobs that exist now that never existed. Were not in existence in 1990. So vocational witnesses would have to say, well, this job as a, I don't know, some sort of a computer, let's say social media manager, okay, did not exist in 1990, but the equivalent would be, some sort of a researcher or something, I don't know, or public relations specialist, something like that. But it's not exactly the same thing. So Social Security realizes the DOT is outdated and really not all that useful anymore. So now there's a number of other resources that can be used, and there's a number of there are vendors out there that produce computer programs. I'm rolling on the cord here. I don't want my sound to pop out because I rolled over the cord, but I can't seem to do anything about it. Oh, there we go. Okay. I'm still using a corded microphone because it is a, it just gives me a little better sound than the wireless one. Okay. So anyway, we've got a, Dictionary of Occupational Titles, which is extremely outdated. We have a number of other publications or other resources. Job Browser Pro is one that use something called SOC codes, which is like a different type of resource that describes jobs. The problem is that in any one DOT classification, let's say a job as being a public relations specialist, there may be 10 of these SOC codes. So if a vocational witness is trying to estimate job numbers and they're using it based in Job Browser Pro, and they're using it based on the SOC code, what they're doing in many cases is they're saying, well, there are 10 jobs of DOT jobs these made up by these SOC codes. So I'm just going to take the numbers to 100,000 people that have these 10 jobs, and I'm going to say, well, I'm only taking one of the jobs because there's only one of them that's really relevant here. So I'm going to make that, instead of 100,000, I'm going to say it's 10,000 people. Well, that works mathematically, but theoretically, you could have 10 jobs in one code and 150 in another and 30,000 in the other. So, you can, and many attorneys do, they go after the VE because the number sources don't really line up exactly correctly. And so, the gist of the argument is we don't know exactly how many jobs exist for any job in the national economy, which obviously we don't. But Social Security is saying, we recognize we don't know. We're going to let the VEs testify anyway based on their experience. Some attorneys appeal this and they go into this. That's not I've never found that to be especially useful. Now, it could be, and I guess there are remands, and there's some federal court judges will accept that line of argument if there can be proof that the number is way out of the realm of possibility. But, that's one way to cross-examine a VE. The other thing would be if the VE testifies, and I'll give you another example. You ask a VE, what percentage off task can a person be and still maintain his or her job? Some VEs say 10%, some say 15%. Some, I had one the other day, said, well, the literature says it's between 10 and 15%. Is that really, a viable answer? Because if you have VEA saying 10% off task and VEB saying 15% off task, and you've somebody that's 12% off task, what does that really mean? Is that a flaw in VE testimony? Arguably, it could be. There are VEs that will testify about transferable skills from a job that is very unique, to that particular job title. In other words, you could be an ultrasound technician, and are there transferable skills outside the medical field? Maybe yes, maybe no. There are ways to cross-examine VEs, and some of them sort of have this belief about things that you can challenge, and if you can later on prove that their analysis, their assumptions were wrong, then that would be grounds for appeal. I still say if you're basing your case on cross-examining a VE, you're probably not winning. And I just want to win. So to me, going after the VEs is sort of a last resort type of thing. And I think judges don't really like it. So, I'm not saying there's not a place for it, but probably not as big of a place as maybe some of my colleagues believe. But that's, a legitimate difference of opinion there. The rent increases, VA benefit rent doubled. So you canceled your Medicare. So John is in Vegas. John, the inventor, is in Vegas. You have VA benefits, rent doubled. and again, people have to make tough choices when money is tight about, what they're going to spend their money on. Insulin and asthma medication should be over the counter. Listen to, yeah, it's such a common condition now. These conditions, you would think that would be some sort of subsidies, and people should not suffer because they can't afford insulin. Okay, a couple more questions here. MT is 43, had 3 back surgeries, severe scoliosis, ankylosing spondylitis, bulging disc, carpal tunnel, diabetic, neuropathy, peripheral neuropathy at about 23, still not gotten a decision. You've got a strong case medically. The big question is your age, being 43. Can you prove there's nothing at all you can do? That's nothing you can do. That's the big question, 43. But otherwise, you get a good case. Okay, John has a physics final tomorrow. Well, John, you need to get to sleep and go study. Okay, very good. And thank you for joining us. And hopefully we'll see you again at another live stream. Okay. Okay, give me some. Okay, very good, very good. And there are people I had a lady in England. I've had people in Germany. There's an international office, so it doesn't really matter. Okay. How do you know if I have the right disability attorney? Well, if he doesn't look like me, you have the wrong one. Or if he doesn't look like Lindsay, you got the wrong one. Being facetious there. But, your lawyer should be able to explain to you a working theory of your case, what the argument he or she's going to use to say why you're disabled, and ask questions about, the evidence that's being gathered. It's hard because, these cases can take 2.5 years. Not a lot goes on in those 2.5 years. And it's not like you're going to get, your lawyer's going to call you every week to say, well, nothing happened this week. So, you got to do your due diligence early on, I think. That's just unfortunately the way it is. Okay. A couple more here. Joanne says, can the ALJ give little weight to treating doctors but be persuaded by the opinion of the state agency consultant? Unfortunately, yes. There was a change in something called the treating source rule, which basically said that the judge can rely on any medical source, even the non-examining state agency doctor. This is all a reaction to the Eric Kahn case. CONN, look it up if you're not sure what that is. A big fraud case where Eric Kahn was an attorney and he had doctors and judges on his payroll and defrauded Social Credit of millions of dollars. And one of the things he was relying on was the treating source rule, because he'd have this doctor see the person 3 or 4 times. They became a treating source. The doctor would write a supportive report. He would win the case. And, the doctor gets paid, the lawyer gets paid, everybody gets paid, the claimant gets paid. And then the whole thing comes tumbling down. Social Security realizes there's a big fraud here because the doctor was on the payroll and the judge is on the payroll and all this stuff. So they changed it and they overreacted and basically said, we're going to eliminate the treating source rule because one guy screwed it up. Makes no sense to me, but most judges, I will tell you, are not going to take a non-examining state agency consultant's opinion over a treating doctor. But some might, but it's pretty rare, pretty rare. Can I read? Yes, it doesn't matter where you live because it's all done by phone or video. So, feel free to reach out to me at this contact below. What is the future of Social Security? We don't have time for that. I'm hoping that it's not going to change all that much, but we'll just have to see. We will just have to see. Okay. C exam requesting medicals. As Lindsay said, they may not have gotten them. The doctor may not have responded to it. And so you never know. That could be it. Stents, anytime you have stents, that's something significant because obviously you have collapsing veins. So that's something fairly significant. Okay, thank you, Afsana. I appreciate that. William, for the first time. William, you don't be a stranger. Glad to see you. 54-year-old type 1 diabetic, confirmed neuropathy. The EMG revealed carpal. I had that happen on one of my cases just the other day. I was just looking at it, doing my pre-hearing work. Person is a type 1 diabetic, neuropathy, and the EMG. I had 2 cases with diabetics. One, the EMG showed carpal tunnel, which it will show. Other one, the EMG and nerve conductions came back with nothing, but the person still had neuropathy. It was still diabetic neuropathy. But yeah, that's a pretty good argument. Type 1 diabetes is a lot of times a really disabling condition, not because your blood sugar goes too high, because it goes too low. It really swings a lot. And when it goes really low, you pass out and you could die. I mean, it could really be bad. So, I think that's what my experience. That's a pretty good one. Yes, I can represent people in any state at all. So, okay. We are now at, let's see, 2 hours and 5 minutes. So I'm going to go ahead and cut it off now. I will hopefully see everybody here next week at 8:30 Eastern. I'm going to have as a guest, right now I'm scheduled to have Adriana de la Torre. Adriana is a appellate lawyer, federal district court lawyer, and she's been on before and very gracious with her time answering questions and talking about some of the issues that are most relevant in the appeals council, which also tells us about what judges are looking at and what mistakes they're making and what they're doing correct and not correct. So she's always very, very helpful. Thanks again to Lindsay Osterhout, my guest for the first hour. Very insightful, very helpful as always. And to you, everybody out there watching live and also the ones on the recording, thank you very much for spending a part of your Wednesday evening with me. I wish you the best, and we'll see you next week. Thanks a lot.